Hi, this is Jacob Hornberger, president of the Future of Freedom Foundation, with Sheldon Richman, the foundation's vice president. This is the Libertarian Angle, the show on the internet that brings you the libertarian perspective on the burning issues of the day. Sheldon, my initial thought today was to have kind of like a fun free-for-all where we compared the principles of libertarians to those of conservatives and liberals or progressives or leftists, whatever label you want to put on people from the left, and it's kind of just share with people how we're different from them, from both liberals and conservatives. But then, we've got this big Zimmerman case in the news, and while it doesn't raise libertarian issues directly, there are certainly libertarian issues within the context of this particular case. And since it's being discussed and debated all across the country, I thought, well, why not at least touch on the Zimmerman case and bring up some of the libertarian perspectives on it. I blogged on it today, and at the risk of embarrassing you in the public eye here, I know that in your vacation this last week, you spent a lot of it watching the trial on television. So why don't I toss the ball to you here at the beginning of the show and give us some perspectives on the Zimmerman case.
Sure. Yeah, I don't know what that says about me, and people can draw their own conclusions. I'll confess that I spent pretty much all of last week while on vacation watching the trial. The trial began before that, so I did not see everything. I didn't see a good part of the prosecution case. I did catch up by reading and saw replays and things like that. So I'm not claiming I saw as much as any juror saw. That's not true. But I saw and read enough that I think I have a pretty good sense of the case. I think it's an extremely interesting matter. What's more interesting than the case itself is the way people have been talking about it and the way that people have lined up back and forth. I mean, let's start at the very beginning, which I think is an entirely libertarian consideration, although non-libertarians also favor this approach. It's a bedrock principle of Anglo-American law, of traditional Western law, that the state has the burden of proof beyond a reasonable doubt when it brings a criminal charge against someone, and we wouldn't have it any other way, I hope. When the state is going to makes a claim against you or any individual, a charge that could lead to loss of liberty, namely imprisonment, or in a case of a capital case, death, it has the burden. This is both a matter of logic and legal tradition and just darn good sense. The burden of proof is on the state. And the standard is beyond a reasonable doubt. I mean, we don't demand beyond a shadow of doubt. We don't demand 100% certainty because that's pretty much denied us in many, many things, and certainly factual matters, but beyond a reasonable doubt. And if the state fails to sustain that burden, prove the elements of the criminal charge beyond a reasonable doubt, every one of the elements, then the benefit of the reasonable doubt goes to the defendant. And the flip side of this is the phrase presumption of innocence. A jury is supposed to start off with the idea that this is an innocent person. Now let's see, state, show us what you got against this person. And then they put it to the test. Does a reasonable doubt remain at the end? If so, acquittal. Now notice the finding is not innocent. We often equate them, but the finding technically is not guilty. So that's we need to keep that in mind, and that's a good thing. Imagine living in a country, and there have been countries that more or less adopted this system, where the state would charge you with a crime and then say, go ahead and prove you didn't do it. And the default being you're guilty until you prove your innocence. We would not want to live in a world like that. That would be a true nightmare. So this is what happened. We have over a year ago, we have this unfortunate shooting, unfortunate, by any standard at any level, of Trayvon Martin, a 17-year-old black teenager who wasn't committing a crime, but who, according to the defendant, George Zimmerman, raised a suspicion. It's night, it's raining. There had been a lot of burglaries in this housing development. He calls the police, a non-emergency number, and tells them he sees a suspicious person. He gets out of his car, follows him, although at a distance, to say what street he's turning down in order to be a guide to the dispatcher, because he's upset that people who had burglarized homes in the past had gotten away. And it somehow ends up in a confrontation with Martin on top of him, beating Zimmerman. Zimmerman then pulling out a gun. He has a carry permit, pulls out a gun from his holster on his hip, and fires one shot, and that ends the incident. Now we had a trial. At first, it looked like the police were not going to charge. They didn't charge him right away because they say they did not find probable cause to doubt his story of self-defense. But there was this the national outpouring of demand that he be charged. You might remember this from television. Al Sharpton, led vigils, and those things were going on. And eventually, the case was taken away from local law enforcement by the governor, Republican Governor Rick Scott. Turns it over to the state attorney's office, who gives it to a special prosecutor. Criminal charges brought. By the way, grand jury at the local level was canceled, had been scheduled to hear the case. So they shut down the grand jury. Send it over up to the state. They bring the charge. They assign prosecutors. It eventually goes to trial. That's what was going on the last 3 weeks or so. It ends in an acquittal, but the people that were demanding a trial and a charge are not satisfied, because it seems to me they didn't want a trial and a charge. They didn't want a charge and a trial. They wanted simply a conviction without a trial, because I don't see why you're complaining. You have a trial, which everyone says was a fair trial. You have a diligent jury. Nobody points out to any sign of lack of diligence. They deliberated 15 hours. They worked through meals. During the trial, when offered breaks, they said, no, let's keep going. Everybody says this was a hardworking jury that was paying attention. And yet you have a lot of people who are sticking to their initial narrative as if the trial never happened. They locked onto a narrative, which I think is sort of racially based. And now you have people in the street saying Trayvon Martin, the victim, has gotten no justice. That's how it stands right now.
Yeah, I'm glad you brought up these principles of presumption of innocence and the burden that the state has to prove a person's guilt beyond a reasonable doubt. The whole concept of jury trials. I mean, this was a state case, state criminal prosecution. But as everyone knows, the right of trial by jury, and along with other procedural guarantees when it comes to criminal cases, are outlined in the Bill of Rights in the 4th, 5th, 6th, and 8th Amendments. And I think it's important that when there is this national discussion and debate over the mechanics of this particular case and how the verdict came out, that we always remind ourselves of the importance of this principle, trial by jury, as well as the other procedural guarantees in the Bill of Rights. And that's what I blogged on this morning. Because, we take it for granted. We've all grown up with trial by jury. It's been part of America's legal system for, since the inception of the United States. These principles go back through antiquity and English history, and they're all a set of principles that involve resistance to tyranny. Because the state, when it brings charges against people, they're convinced that they're guilty. I mean, so what's the point of having a trial? We know this guy's guilty. Let's just get it done with. Well, the jury trial is an obstacle to that, and it involves ordinary citizens. Now, why did our ancestors insist on the enactment of the Sixth Amendment that guarantees trial by jury? And the reason is because they didn't trust the federal government. This federal government that they themselves were calling into existence with the Constitution, or that had been called into existence with the Constitution. They said, we want guarantees of trial by jury along with other procedural rights enunciated in this Bill of Rights. Now, why would they do that? Well, the answer is obvious, because they were convinced that the federal government would end up attracting the type of person that would do away with these things. They wouldn't have ordinary citizens deciding the guilt or innocence of a person. That's just too unpredictable. They were convinced, our ancestors were, that the prosecutors would select judges and tribunals to try people's guilt, and therefore facilitating a conviction. And there's no question but that they were right. Our ancestors were right to provide this guarantee saying, no, you can't do that. You have to give people right of trial by jury. And the reason we know they were right is because of what the feds did at Guantanamo Bay. When they set up their so-called judicial system there, they at first thought it was going to be a constitution-free zone. They said we're not going to allow any federal court interference with our operations, and they set up this judicial system, and I put judicial in quotation marks, which involved military tribunals, not trial by jury as our ancestors demanded, and presumption of innocence and so forth. Everything's the opposite. And so this is what our ancestors were saying, is that if we don't have these guarantees enumerated in the Bill of Rights, that's what federal officials down the line through the future will end up doing. And so trial by jury has been one of the great protections against the state, against the tyranny of the state, and both at the state level and at the federal level. And it's important that we not take these procedural guarantees for granted, for the precise reason that there's always going to be inroads that are trying to be made by federal officials and state officials on this fundamental procedural guarantee. And I think it's important that we constantly remind ourselves about that.
No, I agree. And this is what bothers me so much, is that people started out with, many people started out on both sides, by the way. People who were sympathetic to Zimmerman and people who were sympathetic to Martin. People started out with a story. They locked in on a version of events that they intuited somehow was the right one. And then it was impervious to any facts that may come out, which is, of course, what a jury is supposed to sift through before making the decision, using the presumption of innocence and burden of guilt principles that we've discussed. But some people, demanded a trial, and then they didn't like the outcome, so they say, well, the trial doesn't mean anything, the evidence doesn't mean anything. I'm sticking to my original narrative, and I really don't understand that mindset. You're welcome to suspect, when a jury finds somebody not guilty, you're welcome to continue to suspect that the person really did it. Anybody's free to do that. I mean, we're not jurors. We don't have to start with a presumption of innocence. We can start with a presumption of guilt, but there seems to be something unfair about that. First of all, just philosophically speaking, it's hard to prove a negative. It's impossible. In many cases, it depends exactly on the type of question, but it's impossible to prove a negative. If I were to say to someone, prove to me you're not a murderer, what would you say? I mean, I can't say, let's say I give you no other information. Sure, if I say a particular night in a particular place, you can say, well, look, I have airline tickets to prove I was in Hong Kong on that night. Okay, that would disprove it. But what if I just say, prove to me you're not a murderer? Prove to me you've never stolen from anybody. What can you do? What kind of evidence is there that you've never killed anybody in your entire life? You couldn't do it. You can't bring in witnesses because there may be a witness out there you didn't bring in. That's not the way this thing should work. It's not just a libertarian consideration or a legal consideration. It's common sense, and it's just good philosophy. If someone makes an affirmative charge, you killed someone on this date at this time, and this was the victim, and this is the means, then a person can, number one, make you prove it, but they can go further than that, and that's what happened in this case. You can go further than that and actually affirmatively show that you could not have done it. Now, that's not your obligation under the law. The burden is totally on the state, as it should be. But you can go further and say, not only have they not proved their case, I can prove I was on the other side of the world on the day this crime was committed and couldn't have committed it. So I don't understand why people, that doesn't mean a jury is never wrong. But, in this case, there's certainly no obvious reason to say the jury made a mistake. And so I don't understand the attitude. What I'm also bothered by is people want to pile on their pet causes into this case. Right from the start, because a gun was used, people wanted to use it to promote gun control. And there was also mention of the concept of stand your ground laws. And so people immediately jumped on that and said, yes, we need to repeal these laws. There's no case for either one of those claims from this set of circumstances.
Yeah, my experience with juries is that they are normally and traditionally very, very conscientious. It's usually a one-shot affair, as you know, where people are summoned in to determine the facts in a particular case, whether a person's guilty or not guilty in a criminal case. And ordinary people take this responsibility very seriously. They listen very carefully to the instructions from the judge. They try to follow those instructions, and they're there in good conscience trying to make the best verdict based on the evidence. And that's as compared to trial by judges. Judges are lawyers, and over time they become jaded. They automatically assume that if the state is prosecuting somebody, that where there's smoke, there must be fire. When they hear somebody claiming to be innocent, they smirk. It's just what happens to you over a period of time. Oftentimes is being a judge, and many times being a lawyer. Even criminal defense lawyers sometimes look at their clients that come in and say, look, I didn't do this, with some skepticism. But juries go in there and they look at it very objectively. They're trying to do a good job. And, of course, compare them to the military tribunals at Guantanamo, which, are designed only to please the president and their commanding officers. And so when you see Obama making a statement that's sympathetic to Trayvon Martin, we know what a military tribunal would do. It'd say, oh, yes, my commander-in-chief feels that there should be a conviction here, and these prosecutors that brought this, I need to do my duty. Now, again, we're talking about a state level, but that's really what's going on at a federal level in Guantanamo Bay. And so I think this right of trial by jury is one of the most cherished principles in American jurisprudence. Now, you raise an interesting point about the gun control thing, because this whole case started out, it seems to me, with the whole idea of stand your ground and concealed carry and so forth. Would you go into that a little bit more detail and how that shook out during the course of the trial as you were watching it?
Sure. Let me mention one thing first, just so viewers will understand the bigger picture, how we see the bigger picture. I can say all that I've already said on this case while believing, and I do, that the system, the criminal justice system, which includes the prisons, the police, the prosecutors, that system has, I think, at its core, a racial bias against particularly young black men. Given the drug war, and I would add the war on guns, both of these things take their largest toll on young black men, individuals, young black males, so they can be late teenage and then, over 18. Look at the prison system. Everybody knows we have the largest prison system, largest population in percentage terms and absolute numbers in the world, in the history of the world, and in the world today. And a huge percentage of young black men have contact with the criminal justice system. And I think that's essentially about drugs and also about guns. And it's not those aren't the only things, but those two crusades are really racial at their base. We all know that gun control gets started in the South after the Civil War to keep freed black men and freed blacks generally from owning guns. So there's no secret about that. So I totally acknowledge and accept the claim that the system in a very strong way is racist. At the same time, that doesn't tell you about any particular case. This is what unfortunately people do. They say, okay, system seems certainly tilted against young black men, therefore that's all I need to know. Trayvon Martin, black, innocent victim. Zimmerman, not black, must be guilty. By the way, Zimmerman is half Hispanic. He's not, you can't even just call him white. He's not white. He even has black in his background on his mother's side. So it's a little bit not quite drawn so sharply, but unfortunately too many people think of it that way. So, but I want to argue that you can maintain both things. You can indict the system for this racism, and I think it's mostly fueled by the war on drugs and the war on guns. At the same time, say, if you look at the particulars of this case, the jury seems to have gotten it right. There was certainly a reasonable doubt, and more so. So I want to say you can do both things. I think a lot of people think you can't do both things. If you're distrustful of the system, then you've got to assume this case worked out the opposite of how it should have worked out. And I just reject that. So on staying your ground, the gun issue, it seems to be quite easy. They have a concealed carry law in Florida, like more than half the states have. He qualified for the permit. I mean, the libertarian position would say you shouldn't need a permit to carry a gun. It's an individual right, which is also acknowledged in the Bill of Rights. So you shouldn't need a permit. But that's not the way the law works today. He applied for the permit. He was lawfully carrying a gun in a holster on his hip under his shirt and jacket, concealed. That's within the law. He's also a member of Neighborhood Watch. Okay, whatever that, I don't see how that goes one way or the other. So the idea that, and so some people want to say any time a gun is used in an incident, and certainly where a life is taken, and where the victim doesn't have a gun, lots of people will immediately jump on that and say, see, that shows you we need gun control. That seems like a non sequitur. You got a lot of gaps to fill in that argument, because I don't see how the conclusion comes from the first from the premise. First of all, you don't need to have a gun to threaten somebody. Okay, you can threaten and kill somebody without a gun. So if an armed person uses a gun in self-defense against an unarmed person, that doesn't go against the armed person, just automatically. I mean, you need more facts. Maybe eventually it does go against them. Maybe he used excessive force and there wasn't really a threat. You have to look at the facts. But just the fact that an armed person shoots an unarmed person it doesn't mean it can't be self-defense, because there are other ways to kill people. People killed people before there were guns. People killed people. And in this case, you have unrebutted allegation of the younger unarmed person on top of the other guy hitting his head against the concrete. So it's hardly inconceivable that he was in fear for his life and felt the only way out of this to end the threat was to use the gun. So I don't see how it's in any way ammunition for gun control, period. Even murder isn't an argument for gun control, because the bad guys will always have a way to get guns, and all you'll be doing is taking them away from innocent people. The stand your ground, a little more complicated, but again, I don't see any case against it, and I hope I'll make it clear why. Let me quickly say what stand your ground is. There's a very old, again, ancient principle in Western law, which is probably as old as the presumption of innocence and burden of proof, that says if you're in your own home, there was the doctrine of, a person's home is his castle. You were sovereign in your home. Even the king couldn't cross the threshold. There's an old saying about the king couldn't cross the threshold of your home without your permission. It was your castle. If it's invaded by an aggressor, by some, thug, you're in fear for your life, or serious bodily injury, or an innocent other person, your fear for their life, you are perfectly justified in using deadly force, whether it's by gun or by something else, to end that threat in your house. There's no duty to retreat. In other words, you don't have to. Your first thought doesn't have to be, how do I get away? You have an absolute right to defend yourself in your home. Now, that can apply outside of your home, in any other location. If you're on the street or anywhere else, there was this principle, the duty to retreat, which meant that if you could get away safely, you were obligated to get away safely. And I assume the rationale for this, and this evolves over a long period of time. This predates legislatures. This is not man-made law. I mean, this is man-made in the sense of human beings are involved, but it's a spontaneous evolution of law, only later codified by legislatures. So it doesn't begin with a bunch of politicians passing it. And John Hassness and others give us reason to think that the rationale for a duty to retreat is to keep violence from escalating, just for the sake of the public peace. So if unless violence is necessary in defense, it should not be used. That's the theory. So there was this idea that if you felt threatened, but you could get away, and call the police or something else, but you could get away, then you were supposed to do that, not just pull out your gun and shoot, let's say. But the stand your ground law, which has been passed in several states, I'm not sure how many, introduces a clarification to that. It says there's not an absolute duty to retreat. If you believe that you're still, even while retreating, you will feel a deadly, a mortal threat. You still fear for your life or serious bodily harm. Even in retreating, you do not have a duty to retreat, and you may use deadly force in self-defense. So I see it as more of a clarification of the right of self-defense when you're outside of your home. Now, I've gone through this very long explanation only to now tell you that it's a moot point, because stand your ground was not invoked in this case. It was talked about originally, and in Florida, if you believe if you want to invoke stand your ground, if you've killed someone in self-defense and you want to argue, I had to stand my ground, I'm outside of my home, but I feared even retreating, I was in danger. You can go before a judge before you even have a trial, and make your case for it. The prosecution can try to rebut it, but if the judge says yes, the facts show me that he was just standing his ground and performing and engaging in self-defense, there'll be no trial. The judge can bar it from going to a jury. George Zimmerman did not ask for that hearing, so he never invoked stand your ground, and it would have been contradictory for him to invoke it because his story is Trayvon Martin was sitting on top of him, banging his head on the cement, pummeling him when he shot him in self-defense. Now that's his story. Well, you can't tell that story and then invoke stand your ground. If you're lying on the ground with somebody on you, there can't be a duty to retreat. Because there's no retreat, no possibility of retreat. So there's no way you can use this case to attack stand your ground laws. And why people are raising it today, and they are, why people are raising it today is it just shows you that they have a political agenda and that facts don't matter.
Well, I think it's any time there's any kind of shooting, the gun control advocates are going to use it as an excuse to call for gun control measures is sort of standard operating procedure. But I'm glad you brought up the thing about the drug war. You know, these people that are bringing up the racial issue in this case, they have no credibility with me unless they're out there in front calling for an end to the war on drugs. Because I don't think you could have a more racist government program, with possibly the exception of segregation and, of course, slavery, than the drug war. I mean, we see how it's disproportionately applied to blacks and to a certain extent Hispanics. It provides the cops, bigoted cops, with the perfect excuse to harass people of color, stopping them on the street, patting them down, planting drugs on them. I mean, it is an absolute horror story. And so if people are concerned about racism in the system, there's your racism right there in this drug war. You want to get rid of that? Legalize drugs, get rid of this drug war, stop giving the cops, especially the bigoted cops, the excuse, the legal excuse to go out there and exact their little bigotry on people in the inner cities and so forth. And on gun control, like I say, people are going to use whatever shooting they can to implement their gun control agenda. That's one of the things that distinguishes libertarians from conservatives and liberals. We say that people have a right to keep and bear arms to protect themselves from the likes of people that are violent. Now, obviously, the law is that you can only use deadly force when the other party is using deadly force and when you're in legitimate fear of your life. If some guy just slapping you around and pushing you around, obviously you can't pull out your gun and shoot him. The law says no, life is too valuable for you to be able to do that. But if somebody is attacking you, raping you, is starting to murder you, certainly you have a right to defend your life. And the only way to do that, and sometimes against people that are much bigger and stronger than you, is with the gun. I mean, the gun is the great equalizer, especially for women that are being threatened with rape and slashing of their throats and so forth. And then, of course, we're not like conservatives. Conservatives bring up gun laws in the context of hunting for deer and so forth. We always talk in terms of the Second Amendment as being a protection against tyranny. That it's not just private bullies that do these things to people. It's governments that do these things to people through their military and intelligence forces. We see that time and time again around the world where people are raped and they're rounded up and they're tortured and they're killed. The idea of gun ownership is that at least the citizenry has the option of, instead of just succumbing to the concentration camps and the torture chambers and the rape rooms, of resisting tyranny with force. And that's what distinguishes America from all the other nations in the world. When that happens to some foreign country, people have to just submit or get out in the streets and protest and say, please don't kill me or rape me, and please don't do these things to my family. Americans have one final option. In case of a doomsday scenario where some tyrannical regime tries to do such things to Americans, and that is that they have a right to keep and bear arms and resist with force. And I think we have to keep that larger picture in mind, precisely because it's cases like this that bring out the gun control people, even though it has really nothing to do with gun control, in terms of stand your ground and so forth, because they're going to use that as the excuse to take away people's freedom.
Yeah. Another angle here is the neighborhood watch, which has gotten some comment, even among libertarians. Somehow they think that casts a stain on this from, on the defendant's case, that he was involved in neighborhood watch. And this is sometimes, I remember this morning I was hearing people call what he did vigilantism, which I don't think it amounts to at all. First of all, he called the police. So you're not a vigilante if you call the police and say there's a suspicious person. You're a vigilante if you just go after the person, like that old great movie Death Wish, and that series Death Wish, where Charles Bronson actually just went out in New York City and was trying to avenge, because his wife and daughter had been victimized by terrible crime. He wanted to go out there and, he would catch criminals in the act, and then he would exact justice right then. That's vigilantism. What Martin didn't, what Zimmerman did, who doesn't qualify as that, so that's totally wrong. But people have, even some libertarians have criticized this neighborhood watch idea because he was working with the cops, and some people think that's wrong. But you could look at neighborhood watch as a form of mutual aid. Neighbors looking out for neighbors, right? Just being aware in case something suspicious happens. Something can happen in your neighborhood that's suspicious. So, it doesn't mean anytime a stranger comes into the neighborhood you should pounce on the person. But on the other hand, especially if there have been a lot of burglaries and it's night and you see somebody lurking around who you don't recognize and is checking out houses or something, how is it not mutual aid for people to be looking out for each other in their neighborhood by, and I don't mean violently confronting, but at least alerting, we're living in a world where there are police departments, of saying, I think there's something suspicious going on. That in itself should be no indictment of Zimmerman in this case. It certainly doesn't go to show that he was out to kill somebody that night. And so I think we need to be careful about all this and look at the facts. We can be extremely suspicious of the system as a whole, particularly the drug laws and the gun laws. Look in New York City, where they have the stop and frisk. It's a terrible practice called stop and frisk, which Mayor Giuliani put in. Most of the people stopped and frisked, even though they don't find things most of the time, are blacks and Hispanics. And they're not found with guns or drugs any more often than white people are, but they're the ones who get stopped most of the time. I forget the statistics. But in fact, there's an article coming up in our publication, Future Freedom, on this, and you can find the statistics. I have no trouble believing that a black person, especially a young black male walking through a neighborhood, or a Hispanic person walking through a neighborhood, has much more to worry about than a white person. I totally accept that. You can't use that to say this case was a miscarriage of justice or a travesty. You need a whole lot more than that, and I think we ought to be, much more careful about what we say.
Well, on that note, Sheldon, we got to wrap things up. If you're tuning in on this program for the first time, you can subscribe to our free FFF Daily publication. You can do that online at fff.org, or subscribe, even better, to our journal that Sheldon mentioned, Future of Freedom. It's $25 a year. It's a great way to come in and support us at an entry level. We need your support. It's how we do our work here to advance liberty and libertarianism. And that's the show. And thank you for tuning in, and we'll see you next week.